Welcome back. In this next section, we'll delve into what exactly constitutes a Giglio list and identify the specific behaviors and actions that can trigger an officer's inclusion on it. We'll begin by defining the Giglio list. Then, we'll explore the range of factors, from documented instances of dishonesty to questionable on-duty behavior, that can lead to an officer being flagged. This understanding is essential for appreciating the far-reaching implications these triggers can have on an officer's credibility and career. Let's get started by unpacking these foundational concepts. What is a Giglio list? A Giglio list is a list compiled usually by a prosecutor's office or a police department containing the names and details of law enforcement officers who have had sustained incidents of untruthfulness, criminal convictions, candor issues, or some other type of issue placing their credibility into question. What triggers a Giglio list? Officers typically get placed on a Giglio list when evidence emerges that could undermine their credibility as witnesses in court. While there isn't a universal, formalized list across all jurisdictions, various entities maintain internal records or notes on officers whose reliability may be compromised. Here's how and by whom this process generally unfolds. Instances of documented misconduct, dishonesty, or unethical on-duty behavior, often uncovered during internal affairs investigations or external audits, can trigger a review. If these findings suggest that an officer's testimony might be unreliable, the information becomes subject to Giglio disclosure requirements. Internal affairs departments and other oversight bodies within law enforcement typically compile this information. However, the key responsibility for disclosing such information in court rests with the prosecutor's office. Prosecutors are required under the Giglio rule to reveal any evidence that might impeach a witness's credibility to the defense. The decision to effectively flag an officer involves assessing the documented evidence of misconduct. If the evidence is deemed material meaning, it could reasonably affect the perception of the officer's credibility in court. The prosecutor, often in consultation with internal review boards, may treat that officer as Giglio material. Judges may also flag officers who they will not allow to testify in their courtroom. As we mentioned earlier, being placed on a Giglio list can have significant legal implications for an officer's career and their ability to testify in court cases. The legal implications of being placed on such a list are multifaceted and can profoundly impact an officer's professional trajectory and the legal outcomes of cases they are involved in. In just a moment, we're going to watch a video that takes a closer look at the serious consequences officers face when they are placed on a Giglio list. As an instructor, I want you to keep in mind that this list isn't just a technicality. It's a crucial part of ensuring transparency and accountability in law enforcement. The video will explore not only what leads to an officer's inclusion on the list, but also the professional, legal, and personal repercussions that follow. While viewing, think critically about the balance between protecting the integrity of the criminal justice system and the impact on the officers involved. How does this process affect public trust in both law enforcement and the legal system overall? Let's watch and reflect on this important topic. As you watch, please consider these points. The impact on credibility. Reflect on how being flagged as unreliable can affect an officer's testimony and the outcomes of legal cases. The professional and public repercussions. Think about the broader implications for both the individual officer's career and public trust in law enforcement and balancing accountability and policing. Contemplate how maintaining strict accountability measures might sometimes conflict with the challenges of effective policing.
A few bad apples. That's typically how law enforcement officials describe officers who get into trouble. But it might surprise you to learn that there is an actual list of bad apples with 76 names of local law enforcement employees. All but 2 have quit or been fired. On Your Side's Ann Schindler investigates why these officers are still on the beat.
My experience over 35 years is the vast majority of law enforcement officers are honest. Absolutely.
Attorney Tom Bell represents criminal defendants, but he still depends on the word of honest cops.
There's kind of been a presumption that police officers are going to be reliable and truthful.
That's not always the case.
Here to announce the arrest of an employee, 5-year police officer with the Jacksonville Sheriff's Department.
When a law enforcement employee is charged with a crime or disciplined for lying, they're considered damaged goods, a liability to prosecutors. They're placed on what's known as the Brady Giglio list, a list of officers whose problems could affect their credibility in court.
It's not as if it's an option.
Chief Assistant State Attorney Lee Hutton says they created the Brady list because prosecutors are required to disclose anything about an officer's credibility that might benefit a defendant.
Criminal activity, bias, and truthfulness are probably the big three.
That's a huge deal in the legal community. Well, I take that back. It's a huge deal in the defense legal community.
Attorney Melinda Patterson says having a Brady List officer involved in a case is a red flag.
As a defense attorney, we're supposed to be able to read an arrest report and go off of that information as being credible.
If a Brady officer is a key witness, it can compromise the entire case.
That case is going to be dismissed, and that certainly has happened in the past.
It's rare. Brady List officers aren't typically making new arrests. Every officer on the list has either quit or been fired. All but 2. One got a DUI in 2018. The other is more complicated.
Fortunately, it comes down to credibility. Is he telling the truth or not?
Attorney Anthony Rosati has strong feelings about that second officer on the Brady List. He's the reason he's on it. Sergeant J.C. Nobles was placed on the list in 2018 after a judge wrote a 13-page order finding him untrustworthy.
I was shocked to see that. You don't see too many orders where a court will come out and say that officer is not credible.
At issue was whether Nobles had probable cause for a traffic stop. Nobles claimed the driver ran a stop sign, nearly hit his police car, and fled. Witnesses told a very different story of an unprovoked stop that ended with officers beating the man whose face, even prosecutors agreed, was bruised and swollen in his mugshot. The key to the case was Noble's detailed description of the traffic stop, which he even diagrammed during his sworn deposition.
If he's going westbound, the traffic stops go away. So he had to change the story.
Nobles told the judge he realized immediately after he gave that deposition that he'd gotten it wrong, but didn't tell anyone, including the prosecutor, until a year later.
Did he or did he not run a stop sign? Did he or did he not almost crash into the officer? Did he or did he not have a seatbelt on? And all 3 of those issues, the judge found that he did not believe Sergeant Nobles.
In his order, Circuit Judge Bruce Anderson said Nobles' testimony was specifically not credible. He said the sergeant did not seem to have an accurate memory, was evasive, confrontational, argumentative, and non-responsive during cross-examination. And because he found Nobles, quote, completely and materially changed his sworn testimony about what led to the traffic stop, the judge threw out the case.
Bottom line, that was an extraordinarily courageous order. In 35 years, I don't think I've ever seen an order where a judge just expressly finds the officer's testimony can't be believed.
Nobles declined our interview requests, but former police union president Steve Zona faults the judge, not the officer.
I'm not saying he's a horrible judge. I don't have faith in his ruling that officer was not credible, and I think he's wrong.
Rather than being deceptive at his deposition, Zona says Nobles was simply poorly prepared.
He got confused in his deposition, it's plain and simple. And when he got confused, that's when he gave the incorrect testimony in his deposition.
JSO Internal Affairs investigators agreed that the incident showed a lack of preparation, not dishonesty. For that, and for failing to correct his mistake for a year, he was disciplined with formal counseling. Jacksonville Sheriff Mike Williams declined to be interviewed for this story. He also did not answer 10 questions we sent to him, including whether he'd ever read the judge's order or if being on the Brady list changes an officer's assignment.
A finding of untruthfulness is typically, my experience is that officer is either going to resign or be fired.
The fact that Nobles continues to work patrol is unusual, simply because most Brady officers are no longer officers.
An officer is on a Brady list or doesn't have credibility.
Ann Schindler, First Coast News.
Why are they still employed?
On your side.
Let's take a few minutes to unpack a couple of points about the video. All but 2 officers on the list were fired or resigned. In analyzing this situation with the officer the judge found uncredible, we face a critical question. Did the officer lie, or was he simply incompetent? Consider the following points. The testimony error. The officer admitted after his deposition that he messed up and was mistaken. This acknowledgement suggests that he recognized an error in his statement. However, the fact that he waited an entire year to report or correct this mistake raises serious concerns about his accountability. Delayed disclosure. In legal proceedings, prompt correction of errors is essential to maintain the integrity of the testimony. Waiting a year to disclose a mistake can be seen as a deliberate attempt to avoid accountability or as an indication of systemic unpreparedness and negligence. This delay forces us to question whether the officer intended to deceive or was simply too disorganized to manage his responsibilities effectively. The union perspective. A former member of the police union argues that the officer did not lie but was unprepared. This view implies that the error was not born out of a willful intent to deceive, but rather a lack of proper preparation or a failure to grasp the gravity of accurate testimony. Nonetheless, even if the mistake was unintentional, the delay in addressing it still undermines the officer's credibility. The critical question, lying or incompetence. Ultimately, the situation forces us to ask, did you lie or are you incompetent? If the officer knowingly provided false testimony and then hid his mistake, that would constitute lying, a serious ethical and legal breach. If, however, the error was a result of poor preparation and oversight, then incompetence is at issue. Regardless of the cause, both scenarios have severe implications for trust both in the courtroom and within the police force. This case serves as a powerful reminder of the importance of immediate accountability and thorough preparation in legal testimony, as both intentional dishonesty and gross incompetence can gravely damage an officer's career and the integrity of the justice system. This brings us to the end of this section. Join us for our next section where we cover a Giglio questionnaire, a Giglio letter, and explore the question, is an officer on a Giglio list entitled to a name-clearing hearing? This and more coming up when we return.